Welcome to our Summer Innovation Business and Law Center Speaker Series. I'm Jason Rantanen, the Hammer Boyd Professor of Law at the University of Iowa College of Law and the Director of the University of Iowa Innovation Business and Law Center. Today, it's my great pleasure to welcome Professor Chris Seaman and Thuan Tran, who will be talking about intellectual property and tabletop gaming. Professor Seaman is a professor of law and director of the Francis Lewis Law Center at the Washington and Lee University School of Law. He teaches researchers and writes in the areas of intellectual property, property in civil procedure, with a particular focus on intellectual property litigation, especially empirical studies of remedies and other intellectual property litigation issues. You might be familiar with some of his work, his empirical work on willful infringement and injunctive relief in patent litigation, and more recently, his studies of trade secret litigation. His work has been published in numerous journals, and he's won a variety of awards for his scholarship. Professor Seaman received his Bachelor's of Arts from Swarthmore and his Juris Doctor from the University of Pennsylvania Law School. He clerked for Judge Surik of the U.S. District Court for the Eastern District of Pennsylvania and practiced intellectual property law for several years in Chicago before becoming an academic. He's joined by his co-author, Thuan Tran, who recently received his JD from the Washington and Lee University School of Law. Mr. Tran received his Bachelor's of Arts in Cognitive Science from the University of Virginia and served as a paralegal specialist at the U.S. Department of Justice prior to attending law school. In the fall, he'll be joining a law firm in Richmond. Our speakers will talk for about 25 minutes, then we'll open it up for questions. You can type your questions into the Zoom Q&A, and we'll read them to the speakers once we get to the end of their talk. So with that, I'm going to turn it over to our two speakers. Welcome, Professor Seaman and Mr. Tran.
Thanks so much, Professor Rantanen. Please call me Chris. Jason and I go back a ways. So thank you so much, Jason, for that incredibly gracious introduction and the chance to do this presentation. And also thanks to Sarah Clark, who helped set this up and did all the administrative logistics for it. So thank you again. It's really an honor to be presenting today. And this is really kind of a fun article. It's a piece that actually that Thuan, who was my student at Washington and Lee Law, who just graduated and is just going to be taking the bar exam here in a few weeks, right, Thuan?
Just a couple weeks, yep.
Yeah, this article actually started when we had a conversation after class. I think it was when you were my first year property class, Thuan, and we were talking a little bit in that class. I usually do a day on kind of the little bit of the high level introduction to IP, what it is, and a little bit of an introduction to my first year students. And Thuan and I got to talking about board games, and we said, hey, it'd be really cool to at some point write an article on this topic. Because there really hasn't been a systematic treatment of IP as it relates to board games yet in the law review literature. And so kind of out of that after class conversation arose this entire article. So it's really been a privilege to work on this piece with Thuan, who has a deep knowledge of a bunch of different games, and I could kind of bring the IP piece to it. And so it was really a pleasure to work on this article. So what I thought we would do today is, and Thuan, obviously you can feel free to jump in at any point, but I would kind of present the basics of our paper, which is forthcoming in the Iowa Law Review. I've been joking that I really owe the student editors a bottle of champagne because they have published me at various points in my career, first when I was pre-tenure, when I was in the tenure track market, and then when I was up for tenure, and now that I'm a full professor. So I'm very grateful that they've continued to publish my scholarship. And so what we'll do is kind of present the article, kind of the highlights of it, in about 25 minutes, as Jason suggested, and then we'll happy to take questions, comments, and thoughts from Jason and anyone who's in the audience today. So let me go ahead and share my screen, if that's okay with everybody. All right, does that come across okay on your side, Thuan?
Yeah, I can see it.
Okay, great. So let me just go ahead and do a real short introduction. This is the full title of our article is IP in Tabletop Gaming, a Case Study in Law and Innovation. And so you can sort of see here some images from various tabletop game. And we use the phrase tabletop game quite broadly in this article. We are defining it to include traditional board games as well as card games, including deck building or card collecting style games like Magic the Gathering, Pokemon, and the like, that require you to assemble a deck with which to play. It also includes traditional pen and paper RPGs like Dungeons and Dragons. And it can also include games that involve miniatures, things like Warhammer 40K, and other war games that involve physical objects. We are expressly excluding, though, video games and computer games, even though sometimes games, for example, like Pokemon, the trading card game, actually arose out of a video game itself. We're not going to cover in this paper or this talk video games or computer games, nor are we going to cover toys and puzzles, things like Rubik's Cubes, even though some of those cases have some relevance to what we're doing today in this and talking about in this article. They're not directly on point for our purposes, so we'll go ahead and ignore those. But this is, I think, accurately been described as a golden age of board games. We have seen over the past 10 to 20 years a proliferation of high quality, innovative games that have been successful both in the US market and overseas. In fact, many of the new leading Euro style games are actually originally developed over in Europe and then imported into the United States here. And we've also seen that in the past 16 months or so with the pandemic, major growth in tabletop games as people are socially distancing, stuck at home with family and how to pass the time. And so we've seen a huge growth in board games over the past couple years with the pandemic. All right, and so really the kind of the innovation or IP angle here, I'd like to go back to this quote by Professors Dan Burke and Mark Lemley from their landmark article, Policy Levers in Patent Law, recognizing that innovation is industry specific, right? And that different industries will have different optimal rules for innovation. And this can range on one hand from the so-called negative space scholarship that we have seen that talks about various industries in which IP thrives despite the absence of formal IP protection, or at least the participants have decided to, in many cases, opt out of IP protection. Things like fashion design from Chris Sprigman and Kyle Rostiala have written articles and books on this topic, cuisine, magic, tattoos, sports plays. So on one hand, we can think of industries in which IP plays little to no role as a formal legal matter incentivizing innovation. On the other hand, we can see industries like pharma or biotech in which patent rights and other IP protection provide a very strong incentive for innovation of new drugs and therapies, in many cases which they wouldn't be commercially feasible without the exclusivity provided by IP law. And so kind of where does tabletop games fit along that continuum from little to no IP protection to very strong IP protection? Our thesis here is that it falls somewhere in the middle between the two. In fact, IP actually works quite well as it's currently structured to incentivize innovation in the board game industry and other tabletop games, but does not provide such a heavy threat of potential lawsuits for infringement that it would discourage others from developing new games as well. Okay, so why should we care about tabletop games? Certainly they're fun, but sometimes they could be viewed as a diversion. In fact, it is a very robust part of the entertainment economy worldwide. The global market is estimated to be $14 billion for games with a high annual growth rate, almost double digits. And you can compare it to many other sort of IP-heavy industries like music industry and film and publishing, which are in sort of a somewhat similar range in the tens of billions of dollars. And so I think it's by itself a significant and important economic industry. But it's also interesting because, as we'll talk about today, all the pieces of IP kind of play a little bit of a role, but none of them fully cover what goes on in most tabletop games. And so it's an interesting kind of collage of different types of IP protection that can be potentially relevant to incentivizing innovation in the tabletop gaming industry. Okay, one of the other things that is interesting is that while there have been a few studies that have looked at specific parts of IP, there have been a couple of studies, Bruce Boyden and Marquette looked at copyright protection for game mechanics, Shubha Ghosh wrote an article a few years before that about patent protection. There's yet to be an article that has tried to address IP protection as a systematic matter, looking at all different forms of IP protection and how they interact and relate with each other when it comes to protecting board games. And so our article really attempts to be the first to kind of comprehensively cover how IP relates to board games. But before we get to the IP angle, I want to give a quick overview of the tabletop gaming industry and the game design process to kind of help set the stage for that. So I like to think of the tabletop game industry in some ways as analogous to the domestic beer industry, right? There are a couple of well-known conglomerates that through their own games and their acquisitions that have acquired a very substantial portfolio. And we tend to think of these as mass market games like Monopoly and Battleship that are owned by the two biggest players, Hasbro and Mattel. But below that level of sort of the macro game owners, we have a lot of different smaller companies who publish games, often submitted by independent designers that are quite innovative and creative. Here's just a list of some of those better known, but there literally are dozens, if not hundreds of companies out there that are publishing games. Some of them, like Gamewright, specialize in particular areas. Gamewright is a shop for children's games, but ones that are also accessible and interesting to adults. So they're a big popularity in my household. We've got 2 kids. GMT Games specializes in war games, and so each of these kind of these smaller publishers tends to specialize in just 1 or 2 different areas. Okay, well, how do these publishers end up acquiring games? So many times they are actually games are submitted to them, sometimes through a web portal, but often through agents or at conventions. A game designer will come up with a game independently, an idea for a game. They will develop a beta version of it. They may test it both with first their family and friends, and they may test it with a wider audience, including at game conventions, both regional and national. And then once they feel like they've got a game that's sufficiently well developed to be considered by a publisher, then ordinarily they would submit that game for consideration to see whether the publisher is interested in doing an initial run of the game. The game publisher will review the submission. If they're interested, they will then negotiate with the designer for licensing terms, agree to a royalty rate and other contractual terms, and then finally publish the game. And that's kind of been the traditional model going back for decades for independent designers. You can see this is Hasbro's page for submitting ideas. Here, another a prominent independent game company called Stonemaier. It's got some good games like Scythe and Wingspan, has their own submission form. But we've seen in the last decade or so an increasing trend towards self-publishing by game designers, simply skipping the publisher as a middleman and instead directly seeking funding from the gaming community and individual gamers for financial support to bring their games to market. And so Kickstarter and Indiegogo are both platforms that have been used by hundreds of game designers to get funding to self-publish their games. Some of them have been quite successful, both commercially and financially. Game Exploding Kittens, which is a favorite in my household, was initially launched as a Kickstarter project and raised nearly $9 million. Even more recently, Frosthaven, which is a sequel to the well-known game Gloomhaven, raised over $13 million from Kickstarter. And by one estimate, this is a draft paper that was recently put out, over a third of games that are now being published are going the crowdfunding route, which kind of is, again, further expanding the options of innovative new games that end up getting consumed by the public. Okay, so that's kind of an overview of the publishing industry and a quick synopsis of the publishing process. How does IP protection overlap with board games? I'll go through first patent and then copyright and trademark, and then I'll say a few words towards the end about other IP or IP adjacent legal rights and rules that may apply. So patents, again, I'll start patents since that's kind of my own background. I've written a lot on patent litigation and patent remedies. So interestingly, historically, there are quite a few patents that cover games, including Monopoly and Scrabble that are depicted there. So what can a patent cover in a board game? So it can cover a method of gameplay, right? The actual mechanics of how the game works, the rules, what's permitted, what's not. It can also potentially cover the playing surface or apparatus or game parts. For example, here you see the Monopoly and Twister. It's both the rule set and the actual board and rules themselves were covered in those two patents. It could also potentially include modifications, adaptations, derivatives of existing games that are sufficiently novel and non-obvious. So some more recent examples of patents that cover games: Jenga, which I'm sure people have seen or played, a popular brick stacking and removing game. That was actually covered by a patent, as well as a more recent game, laser chess. This was actually the subject of a federal circuit case involving its publisher Interventions and an alleged copycat that infringed its patent. But even though historically patents were a significant driver or significantly involved in game protection, they don't really play that much of a role today. And there's a number of reasons why. A couple of which are that the novelty and non-obviousness requirements make it fairly difficult to be able to get a patent on a game. And really, there's lots of prior art out there. Many games are simply variations of existing game mechanics and would have a hard time, particularly after KSR versus Teleflex, overcoming the non-obviousness hurdle. Perhaps even more significantly, though, patent eligibility also is a significant issue with recent case law, most notably Bilski and Alice, that abstract ideas cannot be patented. And so there are a handful of recent federal circuit cases I've listed here on the slide that have found that games using conventional equipment like a standard card deck or six-sided dice are not going to be eligible for patent protection because they are directed to an abstract idea. There's also some potential hurdles for prior public uses or on-sale bars that may apply. This particularly is something that game designers have to be careful if they are beta testing in a public setting, may potentially create an issue that would then start the one-year clock in which they'd have to file the patent application. But perhaps the most significant is simply the practical consideration. There's a high cost of patenting, usually at tens of thousands of dollars to hire a patent attorney, to pay the filing fees, to prosecute the patent. And in light of all these other hurdles under 102, 103, 101, a fairly uncertain prospect of ultimate success with that outlay. And given that there's many games have a fairly low profit margin, in most cases, it doesn't make financial sense to apply for a patent to protect your games. All right, so let's go on to copyright. Copyright can and does play a significant role in protection, but only of certain aspects of games. Most notably, the graphical illustrations, things like the box itself, the board game, the physical board game, the cards that might be played for collectible card games, potentially the tokens. The expressive text of instructions, again, may be potentially protectable, but as I'll mention in a minute, that is highly limited by 102B about exactly what can be captured on that. Fictional characters in games, and we don't think maybe a board games is this, but role-playing games are in fact a fairly fertile source of sort of distinct characters who appear in published modules and the like. And the same thing is that we might consider certain RPGs like modules with campaign settings, characters, backstories as being sufficiently delineated to qualify as literary works under 102A of the Copyright Act. And then finally, to talk about the derivative work right also plays a significant role when it comes to publishing and developing expansions, variations, et cetera, on existing games. All right, so here's again one of my favorite board games, Ticket to Ride. It's a well-known Euro-style game that involves building trains to link cities and destinations. This is the original Ticket to Ride USA version. You can see that at the very top there is the copyright registration that the game publisher received for it, as an example. Okay, well, there are some, as I mentioned, some very big limits, though. Even though copyright can cover a lot, there's a lot of things it doesn't cover or are expressly exempted from copyright protection. And the largest one are the game mechanics and the rules themselves. They are viewed as being unprotectable systems, processes, or methods of operations under 102B of the Copyright Act. Goes all the way back to the Baker versus Selden case by the Supreme Court that held that a new method of bookkeeping was a system that was not qualified for copyright protection. If it was protected at all, it would be protected by the patent laws instead. But there are a number of other doctrines, for example, stock characters or features. So for example, if you were designing an RPG, the idea of simply having an elf or a knight or a warrior, those kind of archetypes are sort of common within the public domain that are free for all to use and can't be protected by themselves. A fair use doctrine may potentially play a role as it does in many other areas of creativity. And then finally, there's some interesting case laws holding that the mere playing of a game does not qualify as a public performance because the game merely provides a set of rules, is instead the individual's decisions and actions that are being made, which qualify as sort of essentially taking the existing rules and then actually doing something with them in a way similar to a game of soccer involves a known rule set by the individual players, then actually play the game and how they play the game is sort of the individual creative work rather than the rule set itself. So trademarks are a third source of protection. For example, you can see here some monopoly-related trademarks that Parker Brothers, which is now owned by Hasbro, has obtained over the years. And so that can cover, obviously, the name of the games, the logos, the slogans. It can also potentially cover trade dress, like packaging, colors, and fonts, if they are sufficiently distinctive to indicate a source of origin. Again, most cases that would require secondary meaning, that it would be popular and well-known, and therefore that a significant portion of the consumer base would identify the trade dress as indicating a source of origin. There are also a number of trademark limits to protection. So interestingly, there's actually a leading case about genericide, anti-monopoly case from the Ninth Circuit that actually involves a game called Anti-Monopoly that was a parody of Monopoly. The Ninth Circuit had found literally the word monopoly was generic when it came to a board game because the goal of Monopoly is in fact to become a monopoly, to be the only player left that owns all of the properties on the game. Congress swiftly reversed that decision in the Trademark Clarification Act of 1984, but it's kind of an interesting footnote. Again, there might be parodies of existing games. Here are some parody games that came out that would be protected, even though they might arguably have it, otherwise be infringing on someone's trademark. And then some cases, functionality. I'll briefly talk about the tapping mechanic when it comes to Magic: The Gathering card game when I get to our case studies as an example of something that was allegedly protected by trademark, but in fact was functional and part of the game itself, and therefore couldn't be protected by trademark. Okay, some other IP adjacent areas of law. I'm just going to try and wrap up here in the next 5 minutes or so with design patents could cover, for example, ornamental aspects of games. So if you have a particular chess actually is a good example of this. There are lots of different designs for the various figurines in chess, and so there are design patents covering different ways in which you can have the ornamental chess objects. Right at publicity, I put an example up there from a game that Thuan and I talked with one of the game designers called Unmatched, published by Restoration Games. They have Bruce Lee as one of the characters in the game. They actually had to go to Bruce Lee's estate, actually his daughter, and get permission to include Bruce Lee as a character in the game. And you might also see trade secrets and idea submission law as potential protection for designers who are creating games and want to submit them, but also want to reserve the rights and not, for example, have the publisher, share that information with others or publish it without their consent. So those might also provide some protections for game designers. Okay, we also talk about a few case studies in the article. I'll give you a high-level overview of the case studies, just to give you an idea of what we're talking about here. So one of our favorite is Dungeons and Dragons, which if you really think about it is really kind of two parts. One is the the basic rule set. D&D has a very elaborate rule structure about how do you resolve things like actions and combat and spells that you can cast and weapons that you can use. And so the very detailed rule set that's delineated in the core rule books, plus some of the supplemental and optional rule books, that's the kind of thing that wouldn't be protected by copyright because it's literally a method of operation. So what D&D has done is they've actually created what's called the Open Gaming License. It's currently in its 5.1 version to actually allow creators to openly license the rules of the D&D game, or at least some of the rules, not necessarily all of them, so that others can then create compatible supplements and modules to be used that work with D&D's rule set. And the other main part of D&D is sort of the campaign or the content settings, and those are published in a variety of modules, both by Wizards of the Coast itself, which owns Dungeons and Dragons, but also under the Open Game License by independent creators. Okay, second, Magic: The Gathering, which as I mentioned is a collectible card game created by Richard Garfield, who was at the time a PhD student in mathematics when he developed the game. It is perhaps the most lucrative game out there today. It's easily pulling in hundreds of millions of dollars for Wizards of the Coast and his parent company Hasbro, according to recent public filings by Hasbro. And it consists of literally thousands, if not tens of thousands, of individual cards, which have elaborate graphical art, text that talk about the features of that card, the attributes, the characters, or what benefits they provide in playing the game. Some of these cards are incredibly valuable. Most recently, a rare Black Lotus card was sold for over $500,000. But also, in addition to copyright protection for the actual graphical art, Richard Garfield actually obtained a patent for the tapping mechanic in the game, which involves turning the card at a 90-degree angle to indicate that it's been played during that particular round. This actually was a pretty contested patent. It's gone through re-examination and been widely criticized, but nonetheless is still validly enforced. Trademark protection, Magic has got, Wizards of the Coast have gotten the Magic logo, as well as some of the other, the names of the various decks, and other parts of it have been trademarked. And finally, they actually put on, at least pre-pandemic, put on live events involving thousands of participants. The most best known of which is perhaps the Grand Prix out in Las Vegas every year that has thousands of players compete in Magic tournaments for prizes. Okay, and the third game that we talk about in the article is Settlers of Catan, the well-known game. We talk about the expansions and variations that under the derivative work right of copyright that have been created. We also talk a little bit about Catan's own, what they call their own fair use policy, which delineates what kind of things they will not sue or will not pursue IP protection over. The final thing I want to just wrap up with are kind of our high-level takeaways. What do we learn from this in-depth study of IP and board games? The first off, I think, is the kind of the robustness of the innovation that's going on. That IP law seems to be working fairly well as currently exists in helping balancing incentives to innovate and also the freedom to create through a wide variety of games, novel game mechanics, expansions and adaptations of popular games, and in some cases, re-implementations of old favorites to new settings. We also see a high degree of user innovation in the tabletop gaming industry. And this is where I mentioned the idea of crowdfunding. You know, you have an idea for a game, you develop some of the artwork, you then go out and get feedback from other game designers who are also players. You can then launch it for, put it on a website to get crowdfunding for it, and then also open licensing and content like the D20 open game license system for Dungeons and Dragons. So a high degree of user involvement and innovation, unlike some other creative industries like film, where the public are merely consumers. And the third thing that we talk about in the article are some of the social norms in the tabletop gaming industry and how they influence innovation. But there is a well-developed community of game developers and creators. We talked with a number of them doing research for this article, and they all talked about how they know other people in the game design industry and how they see each other regularly at game conventions that are widely attended, like Essen and Gen Con and Origins. Board Game Geek at bgg.com is also a central hub for information about board games, as well as user forums giving feedback on all things related to games. We also see a fair amount of sharing of homebrew or home-created content, particularly in the role-playing game industry, where people will share either free or under certain licenses for paid under websites like the Dungeon Masters Guild and Drive-Thru RPG. And we also see a high degree of sharing of mechanics or adapting broad concepts and game mechanics. Things like the dice rolling parts of Yahtzee were recently implemented in a new game by Richard Garfield called Kings of Tokyo. But the blatant ripoffs and copying are shunned, including one example from a recent Kickstarter that was a few years ago, which was found to be a blatant knockoff, and users petitioned to have Kickstarter remove it, which they ultimately did. So that's a high-level kind of summary of what we talked about in our paper. Here's a link to the draft, and I greatly welcome any comments or questions or feedback on it. So thanks, and sorry for going a little bit over time there.
Thank you so much, Chris. So I put a link to the article in the chat as well, so you can click on it and take a look at it there as well. And we've got some time for questions now. So if you've got questions, go ahead and type them into the Q&A. I've got a number already, so I'm just going to start right at the top, Chris. All right, so first question. Thanks for the talk. I'd be curious to hear your thoughts about where the norms in tabletop gaming differ from the law, either being more or less restrictive.
Yeah, that's an excellent question. I think in some ways they kind of actually map fairly well onto what the law is. I mean, I think there's a widespread understanding in the gaming community that the kind of basic game mechanics are free for people to use and adapt to different settings. And I think that generally comports well with the understanding that kind of the rule structures itself are not protected under 102B. But so, for example, you can take game mechanics and adapt them to entirely different settings, or in some cases combine or reuse or add two different types of game mechanics together. So I think in some ways that actually kind of overlaps quite well with what the existing rules are. We also did know, we talked with game designers and in some cases game publishers. They do, I think, at least my sense was, that they do have a fairly good understanding of the basics about IP in some cases, because they work with attorneys. At least in one case, actually, one game designer we talked with was himself an attorney in private practice and did essentially game designing on the side. Thuan, did you have any thoughts on that?
Yeah, I mean, it's very widespread in the game community where you will take an existing mechanic, like, for example, Reiner Knizia, who's a prolific game designer. He came up with a whole host of different game mechanics where you'll see these days there's a lot of, deck building, worker placement, and all that kind of stuff. And it's not really about, whether you copy a mechanic or not and whether that plays into the game. It's more so, how do you implement that mechanic in a unique way? A lot of games you'll see these days, they'll be very simple. For example, a simpler worker placement game might be implemented in several different ways. A simpler version that a lot of people are familiar with is Lords of Waterdeep, which uses the D&D IP. But there's also a variety of different games that use just worker placement as the base mechanic. Like there's a game that's based on cell biology, which is called Cytosis. There's another game called Stone Age where, your people in the Stone Age gathering resources. And so it's about, how you use those mechanics and how you implement them well. What runs into issues where, you take a game that maybe you literally kind of clone the game from, its base mechanics, exactly the way it works, and then just sort of reskin it. We've seen this, I don't remember how many years ago, but there was a French publisher which essentially, basically cloned a game that they had from a submission. And the gaming community very much had a backlash against that publisher, and I don't really know if they're still publishing.
Yeah, and I think, Thuan, it's interesting. You also mentioned something I want to that is kind of in the background but want to pull out, worth highlighting, is the idea of IP licensing, right? Many board games use existing IP, right? Whether it be something like Harry Potter, Hogwarts Battle, or Pokemon, right? In some cases, if you're going to independently design a game, you've got to get an inbound license to use that content in your game. And so that's one thing that we see. We're talked about, the game designers are often aware that, hey, I can create my own game, my own universe, but if I'm going to create one that's based upon an existing IP, I'm going to have to get a license for that. And that's going to require me to, negotiate with whoever owns the IP. And so I think that also adapts fairly well on existing law. So yeah, good question.
So going back to the game publishing process, if a game started off through crowdfunding, can they stay there and continue to crowdfund for future games, or do you see them eventually moving to some sort of formal publisher, of moving towards that formal system?
Thuan, I think it's a good question for you to handle. I know you're probably more familiar with Kickstarter than I am.
Yeah, so what we see with Kickstarter is a lot of these smaller publishers kind of skipping the middleman and using the crowdfunding structure in order to actually get their capital, in order to, make their game and kind of feel out the market to see how many people are actually interested. And it used to be the situation where, if a publisher crowdfunded a game and then just purely kind of marketed it through Kickstarter, it would be pretty rare for that game to hit mass market. But interestingly, at least what I've observed is that a lot of these, not like huge companies, but bigger companies like Seaman or Stronghold Games or any kind of publisher like that, they'll use Kickstarter as kind of a base for getting their funding. And then they'll also have different sort of distribution rights with these major stores such as Target. Then they'll actually, have enough popularity and funding in order to distribute with these. Actually, in Target now, if you look at the kind of the game selection that they have there, there's a lot more games that you might not otherwise see. And there was a whole, I guess you could call it a fiasco within the gaming community, where there was a recent game called Terraforming Mars Ares Expedition, which is essentially a card game that was kind of based off of the Terraforming Mars brand. And there was a little bit of a drama where they raised money through Kickstarter, but then the people who kind of backed the game through Kickstarter got the game later than Target, because Target started distributing the game in mass market appeal. And so a lot of these people were like, well, if we're backing this game through Kickstarter, what's the point if I could literally go to Target and get it faster? And so I've observed, at least, that more publishers are kind of turning to Kickstarter as at least the initial point of generating interest, generating capital, but then some publishers have this kind of distribution right with other major stores.
Yeah, I guess one example, sort of, you see the follow-up on going to Kickstarter too. I mean, the example that I had mentioned, the Frosthaven, is a sequel to Gloomhaven, as a good example of that, where they were wildly successful the first time, and once they've kind of developed that name recognition, they can get additional funding from the crowdsourcing community for sequels or add-ons as part of the game.
So this next question is about, where do you situate this innovation case study? So the question is, I'm curious about where you situate tabletop games in the IP literature. Is the example of tabletop games closer to the white space literature because the IP rights don't really cover the core innovative aspects of the games, the rules and the game mechanics? Or is it closer to core IP industries like publishing and biotech because the IP protection is necessary to get funding, prevent free riding or competitors? And I kind of think about this question as saying, like, is IP driving this? Right. Or is this really about the fact that there's these white spaces that innovation can pour into?
Yeah, and I think that really is one of the key questions that we try to grapple with in the article, and candidly that we're still grappling with. Is IP simply tolerated in this space, or is it actually a driver of innovation? And if I had to kind of put it on a continuum between, negative space or white space, meaning, no, and sort of biotech, I probably would lean towards this side of the continuum. I think it at least when we were talking with game designers, none of them said look, I created this because I knew I could have IP protection and then, make a lot of money on it. They were typically interested in making a game that they could play with themselves and with friends, and they wanted to share with others. And if they could make some money off of it, that was great. But I think very few game designers will go into it with the objective of getting rich. So at least in terms of the design or the incentive to create in the first instance, I don't think IP plays a huge driver on that. I do think it may play more of a role, though, when it comes to the publishers of the games, right? Assuming we're not doing a sort of a self-publishing or Kickstarter type model. Because I mean, one of the things that is interesting about, you know, kind of the open gaming license when it came to D&D is that when it was first created back in the third edition about 20 years ago, they said, look, we want to have our base our rule set be sort of the most widely adopted and used and dominant rule set for RPGs. And that will then allow us to then sell, you know, in addition to having others, you know, create their own content, we can publish lots of modules and sell on additional books that implement that basic rule set for DMs and players to use in their own games. And so I think that publishers do care, particularly about the derivative work right, the ability to not only take the base game of Catan, for example, but also have sequels and add-ons and other additions. I mean, Parker Brothers and Monopoly have literally made an industry out of taking Monopoly and putting in all kinds of different settings geographically, different universities, different fictional universes and the like. And so I think from the publisher's end, it does matter more, but from the game designer's end, not so much, I think. That's kind of my high level take on it. But it's an excellent question.
So this one's a little bit on a slight tangent, but have you looked at tabletop board gaming on Twitch? This is kind of like the video game playing on Twitch or YouTube or whatever platform you'd like, but tabletop gaming. You mentioned there's some interesting public performance aspects of playing a tabletop game, and that might vary depending on the game. But what are your thoughts on IP and streaming or making movies, videos based on playing tabletop games?
Yeah, it's a terrific question. Thuan, you probably spend a bit more time on Twitch than I do.
Funnily enough, I haven't, but one of the things that kind of brings to mind with this question is back, I think it was maybe 5 or 6 years ago, Will Wheaton used to host this web series, I think it was called Tabletop actually, where he would literally play games with various celebrities. And it wasn't through Twitch, but it was still a medium where you would literally watch people play games. And I think what it actually did was it exposed a lot of different games that you otherwise wouldn't really hear about to a wider audience. And it's the same thing with what's his name? Like Matt Mercer and Critical Role, exposing the wide world of Dungeons and Dragons to a wider audience. And I think the interesting thing with because obviously Twitch, when you're a Twitch streamer, you're kind of making a living if you're affiliate, especially when you're charging and getting money from it. And I mean, it's a good base, I guess, to really show off some games. I think it's a little bit more difficult, logistically, because at least from what I understand, sometimes these people play tabletop games on Tabletop Arena, for example, these tabletop simulators, where it's a little bit easier to have the camera versus, if you have a camera with different camera angles with people playing games, it's a little bit harder to kind of really get invested in the game. But I mean, the Will Wheaton series certainly comes to mind when it comes to streaming gameplay.
Yeah, it's interesting, right? The synergy that you see. I mean, if you've got celebrities playing your board game or your RPG online, right, that certainly would drive interest in buying the product itself. And so I think in many ways it's kind of a win-win for the for both sides, both the folks who are actually streaming their gameplay and the game publishers themselves, because it generates further interest in the product. And in some cases, you even see, for example, speaking of the Critical Role, which is probably the number one, it is the number one watched live role-playing game. It turns out that actually Matt Mercer, who's kind of the DM and the creator or sort of the head of the Critical Role Productions, actually has now published a source book about the fictional world that he created through Wizards of the Coast. So you kind of see that actually that circle of creativity kind of coming around there actually in a way that benefits Wizards of the Coast as well.
Yeah, I can really see a need to be careful about how you strike the balance in this industry. You know, we think about large entities like, say, Disney, how aggressively do they force their IP rights against, say, like fan sites? But in a community, right, which is even more integrated with smaller players, like tabletop gaming, you have to be pretty cautious, perhaps, about how you enforce your rights, even if you have potential IP rights. So I'm wondering, are there lines that you saw that when they were crossed, that's when entities started enforcing their intellectual property rights? So what were the kinds of lines that you saw would trigger that in this space?
Yeah, that's a great question. One of the things we talked about the some of the game publishers that we talked with. I think the red line for them was essentially, commercial sales of physical products was kind of the red line. Certainly there have been cases of knockoffs or literal knockoffs, printed overseas and without permission and imported and sold through platforms like Amazon that are clear targets, but also in some cases, rare cases, people creating their own games that are like literally as Thuan has said, clones or literal knockoffs. But that's pretty uncommon. The direct pirating of games that were made overseas without authorization would be more likely, I think. Thuan, what are your thoughts on this? It's a good question.
Well, to add on to that, there's also, an increasing trend nowadays to use like a 3D printer, for example, to print your own pieces. It's very common in, Catan, for example, to make your own pieces and create your own sort of modular game, or when you use a 3D printer and essentially sell these STL files to, send to the printer, and then the person buys it, and then they can print their own pieces and essentially create their own game. And so I'd actually ask you, Chris, about this, it's the sale of it is not exactly of the game pieces themselves or of the games themselves, but they're literal files where a person could sell them commercially over, Etsy or whatever, and then the person just takes the file, prints out these game pieces. Where does that kind of lie in here?
Yeah, and there's this interesting parallel to fan fiction, right? The idea that the people who are sort of like the most avid consumers, the ones who are going to also want to create new content, and how do companies draw that line between what are they going to allow and what are they not going to allow? But I flagged that example of Catan in particular because a number of game publishers, including Catan studios, have explicit policies that say, here are the kind of things that we will say are okay, and here are the kind of things that we view as crossing the line that could subject you to potential legal action. So, sort of in the absence of this kind of gray area about what would be, for example, a fair use or not, companies are kind of setting their own policies and saying, here's the kind of stuff we view as okay, and here's the stuff that would trigger our wrath potentially. So.
Are you seeing norms in these kinds of policies as you're looking at them? I mean, what kinds of things do companies say, hey, this is something that we don't really mind, but this is something that we really, really do mind, besides kind of the blatant, if you make an exact copy of our game and sell it for profit, then we're going to be really, really mad. But what other kinds of things did you see in these policies?
I mean, certainly, personal use or home use is generally fine. It kind of gets to the question of say, for example, you're creating an expansion to an existing game. Okay, what if I give that to a friend? Okay, what if I end up making commercially printed versions and then selling 50 or 500 or giving it to my local game store, right? That's the kind of thing I think that commercial transaction that could lead to wrath, kind of that problem. I think the harder call are things like, hey, I take this existing role-playing game and I create my own, new rule, homebrew rules for it or new campaign setting. What kind of things are okay or not? And that's why, for example, D&D has set up some of the rules and policies about what's okay and what kind of thing you have to get their permission for. The Dungeon Master Guild website, for example, will say you can use our trademarks, for example, like you want to put a campaign in the Forgotten Realms universe, you got to get our permission to do that. And here are the things you have to do to get that permission. You can't just go out and start doing it and selling it as a PDF online on DriveThruRPG without our consent.
I think there's also a degree where you look at websites like Etsy or any website that sells like these I guess, upgraded components of games. You see that all the time where, you look at a game like Catan or Scythe or anything like that, and you think, I want to have a little bit fancier components. They sell those on Etsy. And I think the line to be drawn is from a business standpoint, these companies realize, well, if they're selling these components that are technically based off of our game, they'll buy more of our game. And it's also kind of free marketing in a sense. But once it starts to detract from the actual sales of the games, and then they might step in.
As you were looking at these different practices, did you see any variation on an international landscape? Or you're primarily focused on domestic, but was there anything that you observed on an international landscape when it came to differences in IP protection as it related to tabletop games?
Yeah, that's a terrific question. We were focused on, U.S. law because that's largely what I'm, most familiar with. But that is a fascinating question. We talked some to game publishers who had talked, whether about publishing overseas. Most of the folks we talked with were focusing on the U.S. market. In some cases, they would then sub-license the rights out to other geographic regions to make and sell their games. And that's not uncommon, by the way. For example, Euro-style games, many of which are created and initially published in Germany, they then will often sub-license those rights to companies to publish here in the U.S. But it's an interesting question, and one I'll sort of say that I'm just not a great transnational IP person. I kind of know the basics of it, but we didn't really look into that. But it certainly would be an interesting follow-on project to talk about the differences in other legal systems, particularly continental Europe, since that is another major hub, particularly for board games, and their rules are somewhat different when it comes to like authors' rights and creators' rights than the U.S. model for copyright, which is very heavily utilitarian focused. So that would be an interesting project.
This next question looks at out-licensing of games. Have you looked at licensing of games for movies or television, or the vice versa, licensing of movies or television for tabletop games? We have the memory of the game Clue, which got turned into at least one movie. And then there's like dozens of iterations of Clue. What are your thoughts on licensing to other creative markets outside of the core tabletop gaming space?
Yeah, good question. Thuan, you want to take that one? Take a first stab at that one?
Yeah, I'm trying to think of games that were licensed into actual works other than the movie Clue. The only thing that I could really think of is I think there was like a Battleship movie, which I don't know if it did very well. But the reverse is certainly true, where different movies and different TV shows would be licensed into games. And actually, it's interesting because you look at the earlier kind of history of tabletop games with IP bases. They tended to be kind of games that, you take the IP and you just kind of make like a random game out of it and sell it. And there wasn't a lot of thought put into it. But you look at games these days, I mean, my background right here is a game called Dune Imperium, which is based off of the book Dune, and it uses the likenesses of the different actors in the upcoming Dune movie. And, it was licensed to a smaller publisher. I think it was Direwolf Studios, and it turned out to be a tremendously successful game. And you look at, actually, I have a little prop right here because I just recently got it, but, okay, maybe you can't see it, but it's a Godzilla game that I just picked up at Target. And so you look at the Target shelves, there's games based on like Godzilla, Goonies, and there was a recent game, I think it was maybe 2 years ago, called Horrified, which is based off of the classic, movie monsters like Dracula and, the Wolfman and things like that. And so at least I feel, based on my observations, that these IP-based games are becoming increasingly sophisticated because people are starting to appreciate the fact that sophisticated games that are fun to play, they are frankly better taken in the market as opposed to these kind of throwaway games that don't really have any fun. And the only thing going for them is the IP that they're based on. And I mean, I think it's a really interesting thing to see because, Funko games, which tended to be more known for the little Funko Pops, the little like figurines, they've been pumping out a lot of games that are based on these IPs. Things like, Godzilla, there was a Goonies game, there's a Pan Am game, that all of which are in Target. I think it's going to be really interesting to see how this unfolds.
Yeah, I think it's interesting. Like, we see so much inbound licensing, and I think it's a way for people to kind of continue to be involved or connected with, their favorite intellectual properties, whether it be Game of Thrones or Harry Potter and the various games that have kind of come out of that. We haven't seen, as the question suggested, as many go in the other direction where games directly spawn movies. I do recall a TV cartoon about Dungeons and Dragons when I was younger. I think those are fairly rare, though. The most overlap I think we see is with video games, in which there are actually a lot of video games that have imported sort of knockoff, not knockoffs, but versions for tabletop. I saw there's a recent Fallout game for tabletop, and obviously digital versions of board games as well are quite common.
Yeah. I think there was a Dungeons and Dragons movie when I was in law school, but it was so bad that you may have erased it from your memory. All right, so we have time for one or two more questions. So let's talk about miniatures. Right, miniatures. I mean, these are sculptural works, and some of these miniatures, right, sometimes they are very famous characters. The example in this question is Drizzt from the Forgotten Realms, right? And they're sculptures. So how does that play into the IP landscape here? Is you've got these sculptures that are little tiny miniatures. Do you think that something like Wizards of the Coast would have copyright in these types of derivative works, or have issues with copyright in these kinds of miniatures?
Yeah, that's a terrific question. Right, and this, I think, this kind of pulls together nicely. The copyright and the various difficult questions in copyright that we deal with. Everything from, perhaps the ornamental aspects, what's functional, what's not in a work. The sans affaire doctrine. Certainly, if I'm making a generic knight or warrior or elf. Right, that's going to be okay. But what is it if I, create a 3D model and then print, Drizzt Dessert or any other sort of prominent character? I think that would probably clearly run afoul of Wizards of the Coast IP rights in that particular character. I do recall seeing not long ago, maybe Thuan, you can remember which one it is. There was a Kickstarter campaign where somebody was designing miniatures, and it turned out the miniatures were almost direct knockoffs or copies of a previous game that was already out there. And users in the board game community kind of flagged the similarities between the existing miniatures and the ones that were trying to get a Kickstarter campaign going. And they actually got Kickstarter to pull that off as violating their IP rights. So my short answer is, I think, probably the Wizards of the Coast would, if you're trying to portray specific characters. If you're doing it as a one-off for yourself, they probably won't care. But if it's something you're going to make and sell, I think that probably would trigger, right? It probably would infringe their rights on it. Good question.
All right, we are unfortunately just out of time now. So just want to thank you both again for coming and talking to us about this really fascinating topic. I have more questions, but I'm going to hold them for now and maybe ask you separately and later as I think about them.
Whenever.
Yeah.
And I have my email address up on the first slide. It's seamanc@wlu.edu. Happy to take comments or questions for anybody who didn't get a chance to provide feedback. We'd love to hear additional thoughts on this topic. And
again, the paper is linked in the chat, so you can go check it out and read the whole thing for yourself. It'll be coming out in the Iowa Law Review within the next few months. So thank you again, Chris and Thuan. We have another program, our last program in next week, next Tuesday at 11 a.m. Central. This will be a panel discussion on big data and antitrust that'll be hosted by Sean Sullivan, another professor here at the University of Iowa. So join us next week at 11, and we'll be talking about big data and antitrust. But with that, I'm going to say goodbye. Thanks again, and we'll see you next week.
Thank you.
Thank you.